legislation. I'm proud to be sponsor of Intro 632, which would ensure that the legal standard by which we judge religious accommodations is consistent throughout the state. Unfortunately, currently, New York City is guided by the federal law. As many of you know, Title VII of the Federal Civil Rights Act of 1964 requires an employee to reasonably accommodate religious practices of an employee. That's under the TWA versus Hardison standard. What it does is it defines undue hardship when an employer has to accommodate. And federal law has established that anything more than a de minimis cost or burden, meaning if the employer says there's a de minimis burden here, I don't have to accommodate your religious freedom, I don't have to accommodate your request, they can do so. And this leaves a lot of room for discrimination, and it happens every day of the week. We're joined this morning, I see, by a lot of members of the Sikh community in particular. I represent an area that has a very large South Asian population, many of whom are Sikh, so good morning to you, ladies and gentlemen. Sat Sri Akal. We've heard a lot of stories in particular from the Sikh community by me, but it's not just the Sikh community affected by this, it's people of Muslim faith, of Jewish faith, and other faiths who have certain articles of faith that they wear or things that they do or believe that make them different. And some employees have discriminated against them because of that. And that standard, that federal standard, is so broad that it has really allowed this discrimination to go on. So this bill gives what I think is a more appropriate definition of undue hardship. It is found in the state law, Executive Law Section 296, which defines the hardship as a significant difficulty or expense, meaning it has to be shown to be a significant problem for you, not just a de minimis one. And that little change in standard, not only, in our opinion, will make it easier for people to have their religious freedom, but also send a message. And that message to people and the Commission on Human Rights will realizes, and judges adjudicating religious accommodation claims at the New York City Office of Administrative Trials and Hearings, that the city residents deserve greater protection for respect of religious accommodations, not less protections. The issue with the Sikh community, as many of you know, is the idea that the gentlemen wear turbans and beards. They have not been allowed to serve this city and other places just because of that. And can you think of a more outrageous outcome for people who took that chance that I described before? That chance of coming to this country, and they're raising their families here, and someone wants to join our police force or serve our city in some way, protect my family or help my family with their commute or their lives or their health, and they're being denied. Why? Because they have a religious belief that may be different than somebody else's. When, that to me is an outrage, and that is why we're here today. So we've made some progress in New York City since this issue has come to light. I want to thank the Sikh Coalition in particular, who I know is here today, and they're going to be testifying later, for all their efforts on this issue and for continuing to advocate on behalf of the Sikh community across this country. This type of advocacy has led the New York City Police Department to make an accommodation just recently and allow a gentleman named Mr. Govinder Singh to become the first Sikh police officer in the city to wear a turban. This accommodation is historic for New York and for my constituents. Unfortunately, it's simply a single accommodation, and I look forward to working with the NYPD as well as other city agencies to seek permanent policy change, and I believe this law will be an important step towards reaching that result. There are still many employers and many city agencies that have yet to make similar accommodations. And I am confident that when this bill becomes law, it will improve the lives of New Yorkers who ask for nothing more than to exercise the freedom of religion and their constitutional rights. The reason they came to this country, the reason they took their chances, and the reason they left behind everything they know, wherever they came from, was to come for that type of religious freedom.
I am the program director of the Sikh Coalition. I'd like to wholeheartedly thank the Committee on Civil Rights for the opportunity to appear before you today, and I'm also thankful for Chair Rose's leadership of this committee and Councilmember Weburn's introduction of this very important bill. I am the co-founder and director of programs of the Sikh Coalition. We're the nation's largest Sikh civil rights organization based here in New York City. Since our founding on the night of 9/11, we have been working to ensure that all New Yorkers and people living in the United States enjoy their full rights and liberties. As a community-based civil rights organization, we deeply appreciate the work of the New York City Commission on Human Rights and we have a stake in ensuring that the Commission is fully empowered to protect workplace religious freedom, not only for Sikh Americans, but for all people of faith in New York City. As you may be aware, members of the Sikh community suffer high levels of employment discrimination because of their Sikh identity. In particular, the Sikh turban and beard have often become objects of societal rejection or derision after 9/11. According to a research report issued by the Sikh Coalition in 2008 called Making Our Voices Heard, a Civil Rights Agenda for New York City Sikhs, 1 in 10 Sikhs in New York City reported suffering discrimination in employment here in the city. Most egregiously, right here in the most diverse city in the world, as a matter of department policy, Sikhs may not serve as police officers in the New York City Police Department unless they remove their religiously mandated turbans. While the NYPD recently has made a single exception for one Sikh to serve as a police officer in the city, its general policy is to force Sikhs to make the false choice between gainful employment for which they are qualified and their faith. In this regard, I would add that as I speak, 2 proud turban Sikh army officers are serving with their fellow Sikh soldiers in Afghanistan. Both those Sikh soldiers were honored for their service by City Council Speaker Christine Quinn, Mayor Michael Bloomberg, Councilmember Webburn last year. While we are encouraged by signs that the NYPD is open to changing its policy of telling qualified Sikhs to remove their turbans, it's a travesty that this policy still exists. If Sikhs can serve in the heart of combat operations in Afghanistan as we speak, they can serve right here in the city where many were born and raised as proud members of the NYPD. Beyond the NYPD, which is one of the city's largest employers, the Metropolitan Transit Authority has also singled out Muslim and Sikh workers for discrimination. As I speak, Sikh and Muslim workers who currently work for the MTA are forced to brand their religious headwear with an MTA logo. The MTA began imposing and enforcing this job requirement only on Sikh and Muslim workers a few years after 9/11. Amazingly, one of the MTA workers being forced to brand his turban, Kevin Harrington, who's 2 people to my right, received an award from the MTA as a hero of 9/11 for his genuine heroism in leading passengers to safety as the operator of the number 4 train on that fateful day. The idea that he would now need to brand his turban to do his job and be recognizable as an MTA employee, particularly given his heroism on 9/11, is very disturbing. So I am sure this committee can appreciate the challenges our community faces here in the city. While private employers discriminate, the actions of government employers like the NYPD and MTA is more troubling. If government can discriminate unfairly, if government can force qualified workers to choose between their faith and their jobs, what kind of message does that send to the private sector? What kind of message does that send to our children? So today we're asking every member of this committee and the City Council to support Intro 632, or what I like to call the Workplace Religious Freedom Act. Why support the act? In short, it would close a big gap between the protections afforded by state law and city law for religious freedom in the workplace. Under current city law, employers are required to make a reasonable accommodation for the religious practices of their employees. However, employers like the NYPD and MTA can easily bypass this requirement by showing that such accommodations would impose a minimal, or what Councilmember Webburn referred to as a de minimis difficulty or expense on the employer's business. State law, however, says that an employer can only reject a religious request for accommodation if the request would cause a significant difficulty or expense. The gap between a minimal difficulty and a significant difficulty or expense is wide. In a city as diverse as New York, it's not right that the state law on the books is more protective of religious freedom in the workplace then city law. What we ask of you today, what this introduction will make happen if enacted, is to simply close the gap so that our city law and our state law just match each other. In doing so, you'll ensure that employers like the NYPD and the MTA cannot support irrational job discrimination in the city's law. All we therefore ask is that the city law matches the state's law. That's it. Finally, some may question the need for this introduction since state law already provides strong protections for religious freedom in the workplace. It's important, nonetheless, that this council support this introduction for two reasons. First, it sends a clear message to the public that our city law will be at least as welcoming to workplace religious freedom as state law. This is an important message to send to the public from this legislative body. Second, passage of the bill will ensure, make crystal clear, that the city's Commission on Human Rights and the judges of the Office of Administrative Trials and Hearings are applying a significant difficulty or expense standard to religious accommodation claims and no other standard. It's critically important that the standards to which our Human Rights Commission and city judges are applying are clear. The rights of city employees who use city agencies as an avenue of relief hangs in that balance. I would note that today the proposed changes to city law tracks a national movement to enhance federal employment discrimination law so that for religious accommodation claims. Every year, Senator John Kerry from Massachusetts introduces a federal Workplace Religious Freedom Act. So New York City would not be alone in this fight for ensuring the law is welcoming of religious freedom in the workplace. There's national support for this movement. Lastly, there is a gap in the introduction that I'd like to make note of for the record, and it's one that we implore the City Council to address either in this introduction or at a later moment. This bill does not address what we call the emerging issue of workplace segregation. Under current interpretations of employment discrimination law by some courts, not all, but by some, an employer can lawfully segregate employees of faith out of public view if their articles of faith violate workplace uniform rules, as long as they offer the employees similar pay and similar benefits. So consider the example of a New York City retail store with grooming and a corporate image policy forbidding facial hair. If a qualified Sikh or Muslim man applies for a sales position, the employer must reasonably accommodate the employee's religious mandated beard. However, under the city's current human rights law, the employer can lawfully refuse to hire the Sikh or Muslim man for a sales position and instead only offer him a position in the staff room away from public view. This transfer would be completely legal because the current law says that an accommodation is reasonable if it eliminates the conflict between the employment requirements and the religious practice. I would note in this regard that Mr. Harrington, who's sitting 2 seats from me, his employer put him in the back out of public view, and they have cited this federal law to say that we can lawfully put him in the back because we are giving him similar pay or benefits, and they've relied upon that in their briefings to the federal court in which his case now rests. So sadly, I'd note that even the MTA has argued that it can lawfully segregate Muslim and Sikh workers from the general public unless the workers brand their religious headdress with its logo. The MTA says that the law allows it to force these workers back to the rail yards and out of public view if they do not fit the MTA's corporate image. The spirit of the city's anti-discrimination law is to integrate the workplace, not segregate religious minorities. We therefore ask that the city enact a law that explicitly forbids segregation of employees from customers and the general public on the basis of image policies, uniform policies, and actual or perceived customer or public preference. I hope you agree, and I know you agree, that in our great city, separate but equal is always inherently unequal, not only in schools, but also in the workplace. Please support the millions of city residents of faith and make it clear that separation and segregation are not reasonable in New York City. I thank you for allowing me to appear before you today. New York City is a shining example of religious diversity in America, and we should honor that diversity by strengthening our human rights law without delay. Please pass Intro 632, what I call the Workplace Religious Freedom Act. Thank you.
I'd like to just take the opportunity to thank you all for coming to this hearing today. and know that we understand how important both of these pieces of legislation are to ensure that all of our residents in New York City are treated fairly and equitably, and their religious beliefs are respected, and that people who, as Mark Weprin, Councilmember Weprin said, came here to be a part of the freedoms and to enjoy the freedoms that we have as a course of law are also included in those, and that you have and are recognized at the same level of respect that all New Yorkers are. So I thank you, and this meeting is adjourned.
Employee, that's under the TWA versus Hardison standard. What it does is it defines undue hardship when an employer has to accommodate. And federal law has established that anything more than a de minimis cost or burden, meaning if the employer says there's a de minimis burden here, I don't have to accommodate your religious freedom, I don't have to accommodate your request, they can do so. And this leaves a lot of room for discrimination, and some employees have discriminated against them because of that. And that standard, that federal standard, is so broad that it has really allowed this discrimination to go on. So this bill is what I think is a more appropriate definition of undue hardship. It is found in the state law, Executive Law Section 296, which defines the hardship as a significant difficulty or expense, meaning it has to be shown to be a significant problem for you, not just a de minimis. Legislation. I'm proud to be sponsor of Intro 632, which would ensure that the legal standard by which we judge religious accommodations is consistent throughout the state. Unfortunately, currently, New York City is guided by the federal law. As many of you know, Title VII of the Federal Civil Rights Act of 1964 requires an employee to reasonably accommodate religious practices, and it happens every day of the week. We're joined this morning, I see, by a lot of members of the Sikh community in particular. I represent an area that has a very large South Asian population, many of whom are Sikh, so good morning to you, ladies and gentlemen. Sat Sri Akal. We've heard a lot of stories in particular from the Sikh community by me, but it's not just the Sikh community affected by this, it's people of Muslim faith, of Jewish faith, and other faiths who have certain articles of faith that they wear or things that they do or believe that make them different, and in this one. And that little change in standard, not only, in our opinion, will make it easier for people to have their religious freedom, but also send a message. And that message to people, and the Commission on Human Rights will realizes, and judges adjudicating religious accommodation claims at the New York City Office of Administrative Trials and Hearings, that the city residents deserve greater protection for respect of religious accommodations, not less.